Good afternoon, everyone, especially to all the distinguished guests and all the students who have come for the Justice Verma Memorial Lecture organized by the Center for Human Rights Studies, located in Global University. We'll start today's ceremony with a small video, which is a tribute to Justice J.S. Verma. Distinguished guests to begin the ceremony by lighting the lamp and offering floral tributes to Justice Verma. I now call upon Professor Murthy to guide all the distinguished guests to the dais.
I wish to extend a warm welcome to Justice Iqbal Ansari and Mr. Chaman Lal to the Justice J.S. Verma Third Memorial Lecture, which our university has instituted. I want to tell you more about Justice Verma, the man. He was a person of very high integrity and rectitude, a man who stood for principles throughout his life, who called a spade, delivered landmark judgments. Today, there is a Me Too movement going on. Long before what he did in Vishaka judgment was truly a path-breaking one. And that's not one. There are many other in the Vineet Narayan case or Sri Lekha Vidyarthi and many like Joginder Singh case. He really broke new ground through judicial creativity, through judicial innovation, and in fact, not only during his tenure as a Chief Justice of India, but subsequently as a Chairperson of the National Human Rights Commission, he brought many things into the public focus, particularly the right to health. He created a core group on right to health, and he created a core group on right to food, and he gave a new meaning to a lot of economic, social, cultural rights, and he he spearheaded the NHRC's initiatives on a number of important areas, including mental health, and history will truly remember his role. And today we have Mr. Chaman Lal, who worked with him very closely and who shares his values, and we are so delighted. A person who believes in what Justice Verma stood for is with us today to deliver his memorial lecture. We are also honored that former Chief Justice of Bihar High Court and currently the Chairperson of the Punjab State Human Rights Commission, Justice Iqbal Ansari, is with us to preside over this session. And we once again welcome both of you. And with this, I request Justice Ansari to deliver his presidential address. And before that, may I request Mr. Prashant to introduce Justice Ansari.
We are honored to have Justice Iqbal Ahmed Ansari amongst us to deliver the presidential address. I would like to give a brief introduction of Justice Ansari. So, Justice Ansari started his judicial career as a Grade 1 judicial officer in Assam, and thereafter he was elevated to, after a distinguished stint in the judicial service there, he was elevated to the Guwahati High Court as a judge in 2002. And he presented several papers and delivered several momentous judgments during his time at the Guwahati High Court. And thereafter, he was transferred to the High Court of Patna High Court in 2013, and he retired from the Patna High Court as the Chief Justice in 2013. He has he's been a chairman of the Bihar Judicial Academy from 2014 to 2015, and has been involved in planning and execution of several judicial governance programs after his retirement as a as a judge. Currently, he's serving as the chairperson of the Punjab State Human Rights Commission. We are truly delighted to have somebody with a distinguished judicial record to deliver the presidential address. Please, Justice Ansari.
Respected Mr. Chaman Lal, the distinguished speaker who would deliver the third J.S. VERMA Memorial Lecture, the director of the institution here, Mrs. Verma's daughter is also present here, and my student friends. I call the students as friends because I see no difference between you and me. You will realize as you will grow in the field of law that even if you have spent 30, 40, 50 years in the field of law, you are still learning. This is one subject which you never can claim to have mastered. Ladies and gentlemen, I am not here with the written text. And that may lead to shortening of the speech or may overstep by a few minutes. If it happens, I would request Mr. Chaman to pardon me. I'll try to be conscious because fortunately the clock is very much there. Can you imagine a society where there is no justice, if the society has to be a civilized and orderly society? If justice is required for the purpose of bringing peace to a society, then the fundamental question which you and me would have to answer is, what is justice? I start with a query. I think almost all of you, being young, must have heard the name of the famous film star Salman Khan. I am not saying whether he is popular or not popular, but he is indeed famous. A few years back, he was tried by a court of law on the charge of drunken driving and running away 3 or 4 persons who were sleeping on the footpath. His trial ended with his conviction. Salman Khan's family and fans, his friends said, this is great injustice. The prosecution says justice has been done. The matter goes in appeal to the High Court. High Court reverses the judgment of the trial court and acquits him. Now Salman Khan, his family and friends say, justice has been done. The prosecution says, no, it is great injustice. The victim's family say that we are not concerned whether Salman Khan goes to jail or doesn't go to jail. What we are concerned with is the compensation which had been promised to be paid to us. Then what is justice? Because at least we have got 3 dimensions of justice. Is acquittal of Salman Khan justice? Or was his conviction justice? Or will the payment of compensation to families of the victims would be justice? Justice cannot be something which will vary from person to person. If it is justice, it has to be justice for the whole of the society. Then we have to decide, as I asked you, what is justice? Ordinarily, we will say that justice is said to have been done when a decision is taken in accordance with law. And when it is in violation of the law or in contravention of law, it is injustice. Therefore, what is material is for us to know what is law, and therefore it is also necessary for us to determine as to whether a particular act has been done in accordance with law or contrary to law. And if the law permits his acquittal, neither you can do anything nor can I. And if the law warranted his conviction, then neither you can help me nor can I. If you want to change the law, have a change of law, but as long as you have a law, make everybody accountable to law. What is law? Broadly speaking, you must all be knowing as a student of law that law is nothing but a combination of norms of governance of society. That's the simplest form of definition. Norms of governance will mean how I will behave with my wife, or how wife will behave with me, what rights, if any, I'll have vis-a-vis my wife, or what rights or obligations, if any, my wife will have towards me, what rights my children will have as against me or their parents, or what duties they will have towards their parents, how one neighbor shall behave with another neighbor. This is what law is. There was a time when the norms of governance were decided by the tribal heads. Then it came to be decided by kings and emperors. Today, ladies and gentlemen, we decide what is going to be the norm of governance. How we decide? We elect our own representatives to parliament and state legislatures to make laws. It's a different thing that instead of making law, they do many other things. But their primary function is to make laws for our governance, and since we have elected them, we are bound by the law which they make, irrespective of the fact as to whether the party which has formed the government was voted to power by me or not. Even if I voted for a party X and Y has come to form the government and Y makes the law, that law is applicable not only to those who have voted the party to power, but also to those who may not have voted the party to power. So, and the second important thing which we must remember is that law is something which keeps changing, meaning thereby the norms of governance of a society will keep changing because the society keeps changing. See, for paucity of time, I may not be able to give you adequate examples, but I'll give one. And this example has nothing to do with the integrity or reputation of the doctors. Let me make it very clear. There was a time when medical practitioners were very respected class in the society. They were almost demigods. Nobody ever questioned their opinion, their views, their integrity. What was the result when the society had so much of confidence in them? The position of law was that if there is a murder and there is an eyewitness and he says, I have seen the accused being stabbed to death by means of a dagger in his stomach by the accused. And the doctor says, no, I did not find any injury on his abdomen. He was killed because of a fracture which has taken place at the backside of his head. And that was caused by a blunt weapon. So obviously there is a contradiction between the two. Since we had faith, an immense faith in the doctor, we had no reason to question his views, his opinion. And therefore the law was, or the position of law was, that when there is such a conflict, it is the medical evidence which will prevail. And naturally, medical evidence prevailing means the accused has to be acquitted. Now, today when we go to a doctor and he gives a list of pathological and other tests which are required to be done, we look at the prescription and start wondering, how much commission is he going to receive? It is the same class. There was a time when we had faith in them. Today is the time when we are doubtful of their integrity. Is there any effect on law? Yes, there is. Because a time came when the Supreme Court said that medical evidence cannot always be treated as a touchstone for testing the veracity of ocular evidence, that means eyewitnesses' account of the occurrence. The court cannot choose the easy path of acquitting the accused in case of such a conflict. The court has to decide who between the two is telling the truth. And if the court is of the view that the witness is telling the truth, notwithstanding the fact that the medical evidence is pointing to the contrary, the evidence of the eyewitness can be relied upon, shall be relied upon, and the accused shall be convicted. You find the Evidence Act has not changed. Not a word on appreciation of evidence. But the perception of the society having changed, there is a change in law. There are multiple examples in UK, here and everywhere in the world. I would not like to spend time on that. But we understand this much, that the law gives rights. Unless the right has been given by a law, we don't have any right. And anyone who violates that law needs to be punished. Now imagine a society where there was no law. We were nomads. We were half clad or not even properly cladded. In this kind of a society, assuming a man tried to forcibly catch hold of a woman and commit rape, would she have resisted? She had no formal right. We had no laws. If our conscience says that yes, she could have resisted, then that right will be called human rights. The right with which a person is born in order to live with dignity is the human right. And if a woman has the right to resist law or no law, it's a human right. With the passage of time, we have seen expansion in the field of human rights. But let me also tell you, there has been extinction or restrictions on the human rights that we had in the past. For instance, on the human rights, you can move from one place to another, you are free. Because there were no nation, there were no boundaries, there were no countries. Today you can't. And that's why you have today the law of refugees. So you restrict the right. And depending upon the condition of the society, you evolve your own laws for protecting those rights which are required to be protected for the purpose of enabling a person to live with dignity. So long as we have not realized, or the society does not realize, that the human rights are being violated, you will have no law to control it. I'll give you one example. Many years back, I was flying out of Heathrow Airport to Delhi. I reported on time. This was 3 hours before the departure of the flight, and checked in. Waited for the security call. As we wait here now, 1 hour gone, no announcement of security check. 1.5 hours left, no announcement on security check. I was looking at the board. I was thinking they are not asking, and the flight is being shown on time. When it was almost 1 hour for the departure of the flight, I moved to the counter. And at the inquiry counter, I asked one of the ladies, I'm a passenger bound by British Airways flights to New Delhi. Can you tell me when will you then make the announcement for security check? Do you know what was her query? She looked at me with great concern and asked me, sir, do you have any security problem? And mind you, this is happening with me at Heathrow Airport after we had lost 2 Prime Ministers, one sitting and one former. That means Mrs. Indira Gandhi and Rajiv Gandhi. Because they did not have any such problem. So for them, frisking a person, checking a person was not something which was in their head. Came September 11, and when the tower was blown, though that is now a matter of debate whether it was blown from outside or it was blown from inside. Because there are many people who very strongly believe and scientifically try to prove that no, it's not possible for an aircraft or 2 aircrafts or 3 aircrafts to make the entire tower fall. And there is a statement now of the CBI agent saying that it was an insider job. With the help of bomb, it was blasted. To create a situation there where action could have been taken against the people whom United States wanted. So we are not entering into the debate whether it was inside or outside. But after September 11, mind you, the Defense Minister of India was frisked, not spared. The former President of India was frisked. It was later that so far as the President was concerned, the former President, United States tendered an apology, but not for the Defense Minister. Why? Because it was not pinching them. When Amnesty International used to tell us about violation of human rights in the northeast and the valley of Jammu and Kashmir, they had no problems. Once they have the problem, then the law changes. That's what I want to indicate to you, that even human rights will come to be restricted when the situation in the society changes. I don't know how many of you remember that duo of Nadeem Sirwan, who gave us many melodious music in Hindi cinema. Nadeem was wanted as a conspirator in the murder of Gulshan Kumar. UK declined, saying that no, the police in India torture, and therefore he will not have a fair trial. As against this, there is another case. When you search for it, you will find it. when there was a blast in a particular club and many of the Americans were killed. This happened outside the territorial jurisdiction of both United States and United Kingdom. There were also materials available on record that the alleged co-conspirators had been tortured by US investigators for extorting their confession. And UK wanted the extradition of these people from United Kingdom. So since they were not the citizens of United Kingdom, the offense had not been committed within the territorial of United States. They could not have demanded, and United Kingdom could not have delivered or extradited because the offense was not committed within their territory. So a new theory was developed. I don't know how many of you are aware of this theory of transposition, meaning thereby that an incident has taken place in Chandigarh. The facts of that incident bring it to this place, Hindal University. And if what happened there, if it is transplanted here, is an offense, then he is an offender. And notwithstanding the fact that there were clear and overwhelming materials on record that the co-accused had been tortured, United Kingdom allowed the extradition on the ground that the American Constitution guarantees fair trial, as if Indian Constitution does not have Article 14, Article 21, and no assurance for a fair trial. What a mockery of law. And that is where human rights and human rights activists come into play. We have today a Me Too movement. I'm not against the movement. You are making an accusation against a man, maybe after 2 years, maybe after 5 years, maybe after 10 years, maybe after 20 years, 15 years. And you are going to the media. The statutory authorities or the mechanism provided under the Vishaka that we had heard is not approached. The instruments of law or agency is not approached. But we have a TV debate where it is decided as to whether Nana Patekar has really outraged the modesty of the woman or not. I have no quarrel with the movement, I have no quarrel with the debate. But the debate cannot be to such an extent that it makes a person a culprit, because that's not the business of the media. And that is what we need to remember. Because after all, Nana Patekar also has got human rights. He must also be allowed to live with dignity until the time he is proved guilty. But he is already pronounced guilty. This is denial of human rights. I am repeating once again, I am not against the Me Too movement. I am not against the freedom of movement of women. And you have already heard about CEDAW, I am not going to talk about that. This is Justice Verma Memorial Lecture. And on this occasion, we have to recall him, not only as a man with great vision, very clear concept of law, but a great, great humanist. I was fortunate to have many interactions with him on many occasions. What struck me most was the clarity of his thought and the courage of conviction. What he thought correct or true, he had the courage to speak it out, put it in writing, which is a rare quality to be found today in our society. You can imagine the innovative approach which he had in Vishaka's case. You must remember while talking about Vishaka that in international law cannot be applied to India unless and until it is made a domestic law. Because we are also governed by the Anglo-Saxon law. So this convention, which was their convention on elimination of every form of discrimination against women, it could not have been applied to India because India had not made it into a domestic law. The innovative approach in this case was that Justice VERMA brought a parity between the fundamental rights and the resolutions adopted in the convention to which India was a party. So he held that since India was a party, and this is consistent with the fundamental rights, it needs to be enforced. So a woman has a right not to be harassed sexually or otherwise at the working place, since there was no law. The guidelines were laid down that until the time the legislature makes the law, these are the guidelines on the basis of which a body or an association or the government will function. It could have come only from a humanist who could think, who could do his research of mind. So it is not enough to be a humanist. You must also know how to protect or develop human rights. If I speak a minute or two, I might infringe into the time limit of Mr. Chaman Lal, who is amongst us the doyen of human rights protection. I would therefore conclude, but before I do it, I must thank the organizers for giving me the honor and opportunity, the privilege to appear before you. And I must thank each and every one of you, particularly the students, from the bottom of my heart for being so patient to me. Thank you.
Thank you very much, Justice Ansari, for sharing your views on fundamental questions of law and justice and human rights, and also your personal your views about Justice Verma's legacy. Now we will have the Justice Verma Memorial Lecture being delivered by Mr. Chaman Lal. So before I invite him, I would like to introduce him. We briefly listened to him in the morning, but this would be an elaborate lecture on Justice Verma's legacy and his own personal experience in the field of human rights. So Mr. Chaman Lal has had a distinguished career in public service. He joined the Indian Police Service in 1964, and he served in his parent cadre in addition to serving in different departments on deputation such as the BSF, the ITBP, the SPG. He was also part of the Shah Commission of Inquiry into Emergency Excesses. He's been with the Punjab Police and the Nagaland Police. Some of the very distinguished offices that he has held include IGP in charge during the Operation Black Thunder. He's been the director of the BSF Academy. He's also been the additional director of the Border Security Force and then finally as the Director General of Police in the Nagaland. He retired from the Indian Police Service in 1996, and thereafter he served in the National Human Rights Commission as the Special Rapporteur. His areas of specialization have been child labor, bonded labor, mental health, prisoners' rights, and since 2008 till 2012, he has worked with the Swami Vivekananda Youth Movement, which is a NGO which is formed by a group of dedicated medicos based out of Karnataka, which works in the areas of education, healthcare, community welfare. Currently he is a freelance human rights activist. He works with different NGOs on issues of human rights. In addition to his work, he also is a lecturer in different academies such as the Lal Bahadur Shastri National Academy of Administration, Missouri, the National Police Academy in Hyderabad. He was in the last week itself. He was in Hyderabad delivering, taking sessions at the academy. As a recognition of his contribution in the area of human rights, he has received several prestigious awards, including the Police Medal for Prestigious Service, the President's Police Medal for Distinguished Service, and the National Award of Padma Shri. He's also received the V.R. Krishna Iyer Award for Social Crusade. One of the most distinguished police officer, he's the only police officer in India who has been honored with the Nani Palkewala Award for Civil Liberties. We couldn't have had a better person to deliver the Justice Verma Memorial lecture other than Mr. Chaman Lal. We're really honored to have you, sir, and now invite you to deliver the lecture.
Thank you, Prashant, for the kind words. Honorable Justice Ansari, Dr. Murthy, Dr. Shruti Pandey, faculty members, and students. I thank O.P. Jindal University, and particularly Dr. Murthy, for inviting me to deliver a memorial lecture on Justice Verma, who has been my mentor. I have had and I acknowledge a special presence in the audience, Shobra, who represents Dr. J.S. Verma, her father, in a special way here. I have had a fairly reasonably good police career of 33 years, but what I learned during 11 years in the National Human Rights Commission as a special rapporteur on pro bono basis puts everything of my police careers into insignificance. I learned a lot, particularly from two stalwarts, Justice M.N. Venkatachalaya and Justice J.S. Verma. They were chairman. But Justice Verma was unique. Unique in the sense that he was a thinker, he was a doer also. He was resolute, decisive, no-nonsense type, who believed in getting things done. There are very few people who have this excellent combination of the theoretical richness and also passion for work, and that is what I found in him. Some of his utterings, I always recall, and one was that we say that human rights are universal, and this is not disputed. But the only thing universal about human rights, it's a universal violation. Another thing that he was fond of saying is that human rights culture and degree of the protection of human rights in any society would depend on the quality of governance. So he always advocated good governance, but he was fond of using this phrase of his own, and that was humane governance. And he explained humane governance is good governance with focus on the welfare of the people. He was one who understood police thoroughly. He was appreciative of our difficulties and the challenges that we face, and also was very critical of how we function in this country. And that is why I chose the topic of police reform to explain to you in brief what police reform means and link it with what Justice Verma used to tell me. Justice Verma had, in the culmination of his career, given a report on that horrific incident of gang rape in the Delhi bus in December 13. And that is where he placed rape in the context of justice and freedom of genders, women's freedom. And he emphasized there the need for police reform. And he said the reform for making police autonomous, giving autonomy to the police and improving the quality of police service. He used to say that crucial human rights, fundamental rights, Article 14, right to equality, 15, against discrimination, then freedoms, 19, then 20 about convictions, 22 about arrest, 21, of course, life liberty, 23, forced labor, 24 child. All these crucial fundamental rights depend on an efficient, firm, impartial, non-partisan, professional police service. These cannot be realized. And even otherwise, which freedom is more important? No freedom has any meaning, ladies and gentlemen, if people do not enjoy freedom from fear, bhaya se mukti. And this freedom from fear, who can give this freedom from fear? Only an efficient, non-partisan, honest police, which we don't have. That is unfortunate. But only police can give. And Justice Verma used to say that police has been created as an institution to implement rule of law. That kind of status he accorded to police. But unfortunately, he would add that police has failed to establish itself as a protector of human rights of the people, particularly the vulnerable ones, the SC, ST, other Dalits. Police is known to be anti-minority. Police is known to be anti-women. There are some BPR&D studies which present a very sad but true picture of police. And I'm not ashamed, even as a police officer, to speak the truth before you. 1903 Police Commission had said about police, 1903, that police is generally perceived to be inefficient, it is defectively organized, poorly supervised, inadequately equipped, it is brutal, it is corrupt, callous, and it has similarly failed on one front, winning the confidence and support of the people. This is what was stated in 1903. And unfortunately, a lot of this would apply to the police update also. BPR&D studies show that 65% of the people rate police performance as poor. More than 80% accuse us of discrimination against vulnerable sections. We are accused of being pro-rich and anti-poor. The police is influenced by the social status and income status of the complainant. The police succumbs to political pressure. But these studies also say something in favor of police. 86 or 87% say police is not free to act according to conscience, that police acts under a lot of stress and strain. See the fairness of the people of this country. While condemning police, while criticizing police, they would also appreciate that this is a prayer. And this is what I want you to appreciate. This is what Just Now also said, that police works in a very hostile environment. Police job is dangerous, hazardous, risky, and thankless. Police is judged not by successes but by failures. Police bashing is the favorite pastime of media. Judiciary does not trust police. Confession before police is still not admissible in our system of law. People are not sympathetic. For all of this, We are to blame to a very large extent, that is true, but this is the picture that I wanted to present. But despite all this, people need police all the time. Police is given more and more responsibility, more and more burden. So in the midst of our poor falling image and deteriorating credibility, the demands and expectations from the police are increasing. In such a scenario, the police, the young leaders, the officers that I address, are expected to have that change, respect for the people, following the democratic principles of policing, which are upholding rule of law, respecting citizens' rights, accepting oversight, civic oversight over policing, trying to resolve law and order problems with the minimum possible force, having transparency, having accountability, and the service rule. These are the changes that are required. And that is why when Justice VERMA wrote this report, he mentioned it, that there is an urgent need for police reforms. And he had a clear idea what police reforms would mean. You see, after independence, there have been tremendous changes on all fronts, political, social, economic. But one front remained totally unchanged, and that is the police. Police is still being governed by the colonial laws. Those were made in the wake of the experience of 1857 uprising. The colonial masters wanted a system which could have a tight control over police, a police not to have anything with the people. So that's why that model does not mention people anywhere, people's rights anywhere. Unfortunately, the same thing has continued. We have a remarkable continuity as regards police from colonial times in terms of structure, in terms of role, in terms of answerability, accountability, etc. So I would say the concepts are still colonial and compulsions are democratic. The challenge before the police is that it was designed to control the subjects of a colonial power. And now it is asked to serve the citizens of a republic. Can these two things go together? If it's a question of serving the citizens, it has to be a different. That's why reform is required. And reform, as Justice VERMA also used to say, it would simply mean transforming what we call this police force into service. So emphasis not on force, because our functional mode continues to be aggressive. We are still governed by what I call lion-mouse syndrome. Lick above, kick below. Servility to the masters and oppression of the masses. And we are still serving under twin legacy of the distrust of the people from colonial times and the archaic laws. So until we change all that and get rid of this colonial notion, I am sick of telling my people everywhere, police reform is not police modernization. Police reform is something different. And Justice VERMA was very clear when he used to say, what is needed is a reform in the culture and management of the police. I remember once he said, okay, even if we have your reforms, all reforms, what are you going to do with the internal infirmities? Those internal infirmities, that arrogance, that authoritarianism, anti-people attitude, anti-women attitude, these internal infirmities cannot be taken care of by those reforms that we're talking about. For that, a very drastic change in the whole mindset of the police and also of the people towards police is required. It's not only the police. What do people expect from the police? People must know what police can do and what police cannot do in a democratic polity. And police must not be pressurized to do what is not provided in that. That would be reform. Reform would mean providing a professional, efficient, honest, impartial, service-oriented force, insulated from political and other external influences. Another statement of Justice VERMA, I'm recalling, he used to say, police autonomy is as important as the independence of judiciary. He used two different terms, autonomy and independence. And he said both are equally important for implementation of rule of law, which is the bedrock of democracy. Now, police autonomy, I faced difficulties in Punjab when I was there, when I questioned methods of Mr. Gill and the approach of Government of India, because I always hated when somebody said, give police a free hand. I said, no, police should never be given a free hand. Police can never be given a free hand in a democratic polity governed by rule of law. Judiciary is given a free hand. Media will be given free hand to some extent with responsibility and control. Police cannot be given it. Police must be made completely free to act according to law. And that is free hand for police. That is called what is functional autonomy. Just as VERMA had such clarity of thought on this issue, because most of the people, loosely irresponsible, keep on saying, we'll give free hand to the police, we'll give... He was very clear. And that is what I'm trying to emphasize, that police, unfortunately, is not free to act according to law. There are external... So reform would mean insulating police from all those extraneous influences. As Professor Bailey said, that in India, rule of law has been hijacked by rule of politics. In India, police officers are dictated, and some even try to calculate their decisions and actions on the basis of what they expect the political masters would like to have. This is what is required and what we have to change. Police, there are three main afflictions of police. One is politicization of police. Second is criminalization of police. And third is communalization of police. As a matter of fact, these would apply to administration and other branches, but it's very important in this product. When it comes to politicization of police, it is used as an argument also by police officers that we can't do anything, there's political interference. My experience is it is not interference, it is a nexus between an unscrupulous, unprincipled politician and an over-ambitious civil servant or a police officer. We cannot divorce politics and police completely in democracy. We have to accept that factor. And we have to see that there is no compromise on professional better. It's a long subject. I don't have time to, but this is what major challenge. I simply say, because you may also be thinking that police is not free, police, there is a lot of political interference, but this interference is also a nexus. I have found many police officers very happy with this political interference. They want political patronage because that absolves them of responsibility, accountability, and they can look after. And this reform thing, they don't want. You see, why police reforms have not come? Because nobody wants reforms. Political masters have a perfect instrument, a handmaiden in the form of police to use against their dissidents, against their opponents. Would they like to lose control over police? No, never. So why should they be interested in police? The executive, the other in administration officers, top officers, they would like to control police, but unfortunately, there are many in police, they also don't want reform. Why? Because they want to reap the benefits of this imperfect system. Take as much advice as they can and say, we can't do anything, system does not allow. This is a very convenient excuse, that's it. People, some public feel it is very dangerous to reform policemen. It is very risky. Don't make them respectable and humane. They will become sissies and softies. That is public attitude. Or still public associates police efficiency with aggressiveness. When they come across a person like me who talks law and other things, they say, "Aap galat jagah aa gaye. Aapko university mein hona chahiye." Because public perception is that a police officer must be tough. The police must be. This has to change. So reform is not only the reform of the system, etc., but many things others. Then communalization, I will say, is a very dangerous situation. This challenge that we are facing, you are not aware of the gravity of this challenge. I had been to Ahmedabad during riots in 1969, my first posting in BSF. There were communal riots, and the inquiry report accused police of apathy, inefficiency. I went there in 2002 with Justice Verma. This time it was not inefficiency, it was not apathy, it was complicity of police. And this complicity was seen in Bombay also. Justice Krishna report, you read it. It was seen in Delhi in 1984 also, anti-secretaries. This dangerous trend where the police gets communalized. We were having discussion in Ahmedabad. The commissioner police said, "Sir, what can I do? My men come from the same society. How can I guarantee that they will not be poisoned by this communal thing?" So I had to say, then what is the use of our training? What is meant by oath of allegiance to the Constitution? And Justice Verma spoke far more firmly. But this is the mindset, because if we accept it, then you will have sectarianism. And you had what happened in Haryana during Jat agitation. What did the Jat police officers do? This must be arrested. This is the danger that we are facing. This is what is required when we come to reform. They advance an argument that the society gets a police it deserves. This is the most perverse statement. I have never accepted it. Not now, not even when I was there. Every society deserves the best possible police. We have to provide it. And this statement simply means that we are not serious about reform, that we are not serious about accountability. And if people accept this argument, then what is left? The other thing they say, that police is the mirror image of the society itself. That means if the society is now showing erosion of values, casteism, regionalism, corruption, etc., so the police will also be like that. Can we accept it? Police has to have a higher moral standard than police are given powers to control people. They cannot use this argument. When I address my police officers, many of them remain unhappy because after that they find it difficult. I can impress them, but I can't convince them. But I must share with you that I ask a question. A policeman commits a crime. How would you like him to be treated? Like any other citizen? Or leniently because he's under pressure, does so many things? Or more strictly? Nobody says more strictly, I say. I said when a policeman commits an offense, he commits two offenses. One is the offense mentioned in the IPC, and second, the breach of faith, betrayal. He takes an allegiance to the Constitution that he will protect the rights of the people, and he becomes a predator. Unless we have this kind of thinking, and there are some, they are few in number, but don't think I'm the only odd chap in the whole country. There are many, but still we don't matter much the others. These are the things. I felt tremendous satisfaction when I was in HRC, when I met Justice Verma, and I found that here is a person who endorses these views, who encourages me. And all my life, wherever I worked, my own bosses, they are very particular in describing you. You are rigid, you are impractical, you are tactless, because you follow these things. Justice Verma, as has been mentioned by our Honorable Justice also, the judicial craftsmanship that he showed in Visakha judgment, by using the conventions and treaties which India has signed and doing what Parliament failed to do. He believed in that. There was super cyclone in Odisha. Justice Verma had taken over just 3 days back. So immediately after this was reported, he called us and he said, I want you and the Secretary General to go to Bhubaneswar and visit him. So we could not understand what has cyclone got to do with National Human Rights Commission. But he sent us and he gave us a specific task. And we came back, made an assessment of preparedness, make an assessment of the displacement, made an assessment of damages, the fatalities, loss of property. And then I was involved. And since I was always a volunteer for about 4 months, 5 months or so, I made a couple of trips to ensure that the directions of the NSRC in respect of disbursement of cash, in respect of damaged houses controlled. And one beautiful idea we picked up there from discussion with teachers, that when this cyclone came, those villages which had double-story schools, nobody died there. Because people rushed to the school there. And a decision was taken when one collector told me, then I wrote in my report, NHRC endorsed, and again, that all schools in Orissa, in the coastal belt, 5-10 kilometers from there, must be double-story. And it changed the whole thing. Next time when cyclone came, there was a problem. And this was possible because Justice Verma could think that NHR, disaster management, that force, the idea you will find in the NHRC report on cyclone. Because there we had mentioned that when there was a cyclone in Odisha, Chief Minister Chandrababu from Andhra came rushing with plumbers, electricians, engineers, etc. And he helped in restoring those services. Justice Verma and Rhodes told that state must develop this facility. So we chose one police battalion and we created some platoon there to restore the lost electricity, water, etc. And then it led to the idea of creating a disaster management force, etc. This is the innovation that he. So every Gujarat, we looked into the cases and we recommended 9 cases. I remember I had drafted, if Shubhra might remember, it was a holy day. I was at Justice Verma's the whole day preparing the draft report, and next day Justice Verma completed it, and we recommended that 6 or 7 cases must be given to the CBI. The government did not accept. And then the innovative measure available to the NHRC, because NHRC is not toothless. Its recommendations are not binding. But if the recommendations are not accepted, the NHRC can go through Supreme Court, and we went there. Then Best Bakery, Bilkis Bano, all those cases which you hear, those are the cases which Justice Verma had transferred, referred to the Supreme Court, and then we got there. They established 4 principles of policing in Gujarat. The first was clearly written that the state is responsible for all violations by acts of omission or commission of all people, all people. Second, the state will ensure protection to all without any discrimination of any kind. And the most important was, the state is responsible for the conduct of not only its agencies, but also non-state actors in its jurisdiction. It is implied, it is understood, but no one has put it so nicely, so clearly, that you cannot say that they are terrorists, they are non-state actors, we can do nothing. It is your responsibility. It is your responsibility to protect. So this responsibility in respect of non-state actors given to the state, that is what this one is. And the last one, that if there is any violation of right from inaction, it is also a violation. So violation is not only by omission, commission, abatement, which is already known, and negligence. These 4 are known. And he said inaction will also be there. I'll conclude by saying that Justice Verma firmly believed in a particular interpretation of Article 21, which says that all government actions, even in exceptional times, must bear the test of reasonableness, non-arbitrariness, non-discrimination, which means it is not a matter of life and liberty, it's not a matter concerning police only, it concerns the entire administration and governance, that their actions have to be just, fair, and reasonable. This is what he put it. Then the other thing that he used to emphasize on my request, because wherever I took him to there, and that was that a popular belief in police, that there is a clash between security and human rights. And you will come across. Some of you might be thinking also that human rights means it is just not possible to ensure. If security of the country must be above, human rights can be sacrificed. Human rights are important. Security is more important, no doubt about it. But is there a clash? We were very clear that respect for human rights and genuine concern of the security have to be accommodated, and they must be accommodated. And Justice Verma used to explain by saying that this concerned the constitutional values, core values, and refer to preamble, where what do we say? Ensuring the dignity of the individual at one hand and the unity and integrity of the other. That means it is our responsibility to govern this in a country in a way that the country remains united without sacrificing the liberties. So we should not accept those people who say, just make us free of this rights business. We will deliver results, we will do everything. No, we have to ensure. Professionalism means that we have to dive, we have to be prepared for a sacrifice in that, because this is the most sacred task, ensuring the unity and integrity of the country, but without assaulting the rights of the people, because this is rule of law. If you are going, what is the purpose of the rule of law? Establish human rights. If you are saying that you are establishing rule of law at the cost of human rights, it is totally wrong. This has to be there. And this is what I always felt, but this is what I learned in a special way from Justice Verma, and that is why he is still so dear to me that I cannot forget him. Thank you very much.
Thank you very much, sir, for your views, highlighting the importance of police reforms and also highlighting the contribution of Justice Verma, who recognized this important issue. May I now invite Professor Murthy to felicitate our distinguished guest as a token of appreciation from our side.
I just want to say a big thank you to our chief guest who presided over the Justice Verma Memorial Lecture, Justice Iqbal Ahmad Ansari, Chairperson of the Punjab State Human Rights Commission, and also to Mr. Chamanlal, who delivered a passionate address. In fact, Justice Verma gave a landmark judgment in the Vineet Narayan Jain Hawala case. He took pains to ensure that CBI was insulated from all extraneous pressures. In fact, he gave detailed directions on how the CBI chief should be appointed, what kind of tenure should be there, how it should be fixed. And then he's, throughout his thing, he kept advocating for insulating CBI from all extraneous political and other interference. Today, if you see what's happening in CBI, it's Justice Verma would be a very troubled person. And that again underscores the need to ensure that whatever he laid down is strictly followed. And I'm really thankful to Mr. Chamanlal for flagging the need for police reforms. In fact, as I said in the morning, during the course of my lecture, 2/3 of or more of the police, the complaints received by Human Rights Commission in Delhi are against high-handedness of police personnel. And sometimes it's a question of arbitrary arrest, or sometimes it takes in more varied forms like false implication, custodial violence, and so on and so forth. And if police reforms are strictly implemented, if police have a security of tenure, if police are insulated from all types of interferences, then there is a scope for better protection of human rights. And I'm really thankful to Justice Verma's daughter, Mrs. Subra Verma, who is present here, and for participating in this event. Thank you. And I want to thank all the students who have passionately sat through the entire day. And all your certificates are ready. And since there is a time is short, we were going to give it to the volunteers who will distribute after this function is over. Once again, I want to thank all of you for participating in this function. With this, Justice Verma third memorial lecture is over. Thank you.